Hi, folks. You're with Tacitus today. Tacitus today, your pushback channel, and thank you for joining this audio live stream. In this essay, I'd like to talk about the so-called rogue judges in the United States issuing national blanket injunctions on the policies and processes of the President Trump's administration. Now, I guess the question is, are these actually rogue judges? Because if they're ideologically corrupted or financially corrupted or corrupted in any way where the law and the Constitution is of minimum, if not any relevance to their determination, then there's a problem with why would you appoint people that are so compromised in attitude or behavior. Also, when the concept of judges was originally considered, in the original documents of the United States founding and Bill of Rights and subsequent amendments to the Constitution, the view was that legal scholars, people of great repute who had civic obligation to the nation and so on and so forth, would be appointed. The idea that there would be radical activists being appointed to judicial positions in order to undermine the very Constitution they've taken an oath to defend. That was never considered as part of the, no one thought that could ever really happen. We were all going to be, white Christian, West European people, and primarily Protestant and so on. So the homogeneity of the society was the protection, or a layer of protection that was considered, well, this law, it's always going to be this way. The idea of people with completely alien and very different views as to what the law really was, is it for restorative justice? Is it to protect the oppressed, or is it simply a scholarly matter of interpreting the law? These weren't ideas or concepts or practices that were considered in any form of conflict back in the day. So events have moved beyond what the original concepts were. The society is no longer homogenous, far from it, in the United States. The ideas and the views and beliefs that the law is a matter of interpreting the law and the Constitution, that too has changed very substantially. That many now see the law as a way to re-engineer society and to engage in restorative justice going back many hundreds of years, and so on and so forth. So we're in very different times, and should the power of judges be altered or limited or contained or more further codified, or should the procedures be changed to reflect that? So that's really the essence, I suppose, of this essay. So coming now to Judge Karen Immergut, who was recommended to Trump by the globalist activists that were around him during his first administration. But just looking at what I've seen of her background, it's not obvious that she's a leftist radical or something like that, although some of the work she's done do suggest sympathies in that direction. But nonetheless, so the judge issues, this is Judge Immergut, issues an order to say, well, the Trump administration can't move National Guard troops or National Guard people into Portland to contain or deal with the Antifa rioting that's there, and the brazen activities of Antifa in interfering with and opposing the ICE officers in detaining and arresting illegal aliens, particularly criminal ones, and then processing them for deporting. The Antifa activity here suggests, certainly the brazenness of it, suggests people who are very confident they're not going to be held to account, and suggests a level of organisation and political intent. This is not just rando grassroots folks. This is an organised movement of political intent to thwart and flout the policies of the Trump administration, and indeed thwart and flout the law itself. An illegal immigrant is still illegal, no matter what you may or may not think politically of the Trump administration. The idea is anything that leads to or as part of the effort to expel illegal aliens is illegitimate in a globalist sense, is illegitimate and therefore must be opposed. Indeed, it's an obligation, a virtuous obligation of people to oppose it, is the wider political intent of these actions. So the administration of President Trump moves to oppose these rioters and to make sure that not only they don't interfere with the ICE activities, but those who are breaking law are arrested and brought before the courts, charged and brought before the courts. So far, there's nothing really wrong with that. Now, the Democrats, who I think we can reasonably and without much demur can accept that they are the party of the globalists. They are there to enforce and implement the globalist project, to not allow anything to interfere with the globalist project and its intent in terms of mass migration and attendant social engineering and so on. So there are two political objectives being played out here. One is the lawful one. The other is that opposes the lawful one on the basis of ideological grounds. So the administration of President Trump is, I would think, and President Trump is the commander-in-chief of the military forces. The administration of President Trump is, well, as far as I can tell, within its rights constitutionally, legally, to uphold existing laws that exist currently on the books and have for a long time, and implementing those laws and following through. The judge, however, sees it differently. Now, I think the activist attorney generals of two Democrat, very leftist leaning, very pro-globalist, super pro-globalist states looked around, got a judge to get an injunction against the Trump administration's policy, the Trump administration's mobilizing of the National Guard. Now, how do these things happen? This is where the procedural issue arises. So someone's got a complaint, or they want to oppose a policy, and in some cases they want to impose a possible intended policy. That is, there's been no transgression or law breaking or constitutional transgressing or trespassing on the Constitution at all. But these people say, well, there might be. They might do it. So this moves into the area of ideology. So they have to go to a judge and say, well, look, those Trump guys are all bad. They're all bad, and they intend to do bad things. We will say that they may or might intend to do something tomorrow, the next day, next week, where they might intend to. Why? What makes you say that? Well, they're bad. They're bad people. Therefore, fascists, Nazis, Hitler, swastika. So we want you to say that if they attempt to do this thing because they're bad, then that's an injunction against what they might do. Now, this is astonishing. This incredible overreach of the judicial remit, I would argue. But the pro-globalist people are able to find, effortlessly it seems, find judges who are happy to agree to this and go, yep, we'll give an injunction. So procedurally, that's a real problem. That has the actual transgression taken place. Now, the other thing is that the organised globalist sort of legal scams can, where unofficially these people can go and sound out a judge before. Well, there's no use going to a judge to get a decision. The judge says no, get lost. And very, very rare any of these people turn down. Why is it they seem to be almost guarantee an outcome in their favour by pre-selecting judges? So through the backdoor channels, through the administration staff, the NGO activist staff, the vast network of activists, they can quietly sound out the judge beforehand. It's okay, if we bring this to you, and with scant, if not zero evidence or hardly any evidence, we're just going to make an ideological case. Those guys are bad, therefore whatever they do is illegitimate. That's really the size of the legal case as I understand it. They're able to quietly sound out the judge in background, informal channels, And the judge goes, yep, I'll give you the injunction if you come before me. So it's already a pre-arranged, pre-done deal. They can walk into the court with a pre-arranged thing. They go through the motions. Only one side goes through the motions to say, yeah, this is it. And a lot of ideological nonsense. 10 years ago, Donald Trump said that he wants to evict illegally. This means he's a racist, which confirms that he's the bad guy, therefore confirms we have to oppose it in the interests of social justice. And then the judges go, yep, signed off, here you go. Now, if you look at the time it takes to write up the finding, the time it takes to write the findings from the time that the writs, if you like, the complaints are first lodged, and the time it takes the judge to hear the case, consider all the evidence. There's not much evidence to consider. It's just, again, an ideological play. But to consider and then write up the judge's finding, reasons for judgment, that sort of thing. And you look at the amount, unless the judge is the quickest typist in the whole universe, they just couldn't do it in that time, or they stayed awake throughout the whole night to write it, which I don't doubt they would do. So this would strongly suggest that the verdict is pre-written, that it's already written up before the judge hears the case. Now, this is very much how ideological legal activists work. The pre-arranged, the pre-done deal, everything's ideologically neatly put in place before the scam procedure is gone through, the theatre of supposedly hearing the evidence. So that the whole thing's written up beforehand. I wouldn't be surprised, I don't know this for sure, but I suspect it's probably the case where the activists that are bringing the case to the judge have already written up the findings. So the judge has got a nice, easy job of going, yep, you can have what you want because, she's been pre-sounded out. And then they just produce the written copy of the reasons for judgment. Yep, signed. And the whole thing's delivered as a neat package. I would suspect it goes, if not exactly like that, certainly close to that. And I've witnessed these sort of things up close as well. So I know that it goes on. Now, whether it did in this instance, I can't say, but I suspect it did. So now, if the judge is going to issue an injunction, you would think in order to be, legally even-handed and impartial, and impartiality is issue here. Clearly, we're dealing with a judge who's not impartial. I'll come back to that in a minute. But the judge should then offer the other side, say, well, thank you, guys, for bringing your complaints or concerns about legal transgression to me. I want to hear what the other side has to say before I make a ruling. So now, bear in mind that these people can bring emergency cases to judges at midnight. They can appear on the weekend, Friday night, Saturday night. They can somehow get a judge out of bed in the middle of the night. I don't think it is that. I think the judge has been pre-arranged. So, well, better stay awake tonight because we're going to need you to. So they're able to go to a judge on Friday night or Saturday night, and you never know which judge is going to be on duty that weekend. That's a rando thing. There's judges for emergencies there, but that's a rando thing. So you're not supposed to know. But somehow these activists who bring these, they know which judge is going to be on duty. Isn't that acutely suspicious? And then the judge they can come at midnight. Now at midnight, the judge can say, well, wow, it's an emergency. We got to stop bad orange man. I'll give you your injunction straight away. And therefore, at the minimum, it's going to be a couple of days before the administration can respond with their own lawyers and legal representations and legal documents. The other side can plan it days in advance and then effectively drop it as a legal ambush. Whereas the administration, in this case the Trump administration, has days. It would take days to respond to something that was quickly delivered as an ambush in the first instance. So the judge would typically say, well, look, I need to hear the other side here before I issue an injunction. An injunction is a pretty serious thing, and I need to hear all the evidence. Any judge would say that. I need to hear all the evidence. But instead, they hear one side of the evidence from a bunch of activists, and then they go, yep, you can have your injunction. Now, the Trump administration responded with, well, if the injunction is against bringing National Guard from this place and that place, we'll just get the National Guard from a different place. So we can, so the judge then behaves very strangely. This suggests a huge amount of emotional investment in this. This is not a judge interpreting the law. This is not a judge interpreting the Constitution. This is somebody with deep emotional investment in the process. So the judge then holds a second hearing, a very unusual late night hearing, a telephone hearing, a late night hearing, where the other side can I think, I'm pretty sure the other side, like the Trump administration was, or one of their representatives was on the phone, but the judge says, well, you've defied me. How dare you defy me? I'm a little punk-ass shithead judge, and I'm going to give a nationwide injunction, and how dare you defy me, motherfuckers. Now, this suggests somebody with a huge amount of emotional investment who's also drunk on the fucking power. hey, I'm trying to protect the people against Orange Man Bad, and you're defying me. Again, a lot of emotional investment and I would argue, an ideological predisposition. This is not a judge's job. The judge's job, as any judge, is to interpret the law and the Constitution. Nothing more than that. Nothing more. The idea of having some sort of emotional, how dare you defy me? No, that's not your job. And by the way, you're contradicting the authority of the executive, of the President of the United States, of the Commander-in-Chief of the Armed Forces. Well, you have more authority than the Commander-in-Chief? Is that what you're trying to say, you punk-ass judge? So this is so there was a second hearing in, 2 or 3 days, where the judge quickly and in lightning speed doubled up on her ruling to prevent the Trump administration from deploying any National Guard to Portland. Now, what right did this judge have? Now, the claim that it wasn't constitutional and contravened the amendment, I would argue, in the judge, or certainly what I've seen of the judge's orders, it's drawing a very long bow. This is a serious stretch, and the judge's orders and reasons were very consistent with the ideological position that the activists put forward. So this again, to me, would indicate, in my view at least, that the judge is ideologically corrupted here, and therefore shouldn't be hearing the case. They have too much of an emotional investment in the outcome, which no judge should have. They should simply be an absolutely clinical matter of interpreting the law, again, and the Constitution. So what to do about it then? Because the Supreme Court has issued a ruling about the limits, or some limits, on district court judicial power, but I wouldn't describe that ruling as conclusive or absolute. It seems to, I don't know, almost take a middle course on this. But the reality is that in my view at least, that now the other thing too about this judge that also annoyed me again, which to me suggests activism, or clearly implies it, is that the Trump administration quite reasonably said, well, look, don't put your injunction in place until we've had a chance to present our legal case. We'd like to present a legal case too. The other side has. Well, can we present a legal case as well? And which, again, in the interest of fairness, legal fairness, any judge would grant that in the interest of fairness. But the judge refused it. Now, that to me was critically telling. No, you can't put your case. No, I'm putting the injunction in place without you being able to present your full legal argument. That to me was very telling. Anyway, what to do about this? I don't believe that a judge should be able to do an injunction without hearing the other side. Maybe a 24-hour injunction max, 48 hours absolute tops, and then say, well, I'm not going to issue a ruling until I've heard both sides. Now, if it's to be if the judge has any activist associations, and I think all the judges' texts and the judge's assistant and operatives should all be, the text, emails, all communications should be vetted over this period leading up to that injunction. And I would almost guarantee you'll find NGOs, activists, all sorts of back channel type chatter going on where the judges sounded out, will you give us the injunction if we come to you? And if that is the case, that judge must be forced, required, obliged to stand down and not hear the case. So the idea of activist judges issuing immediate injunctions, has to be stopped. It cannot go on. Just not because it's favors or doesn't favor the administration of the day, but the idea of activists just being able to run rampant through the legal system, that has to be stopped, and that can be stopped procedurally. Either their activism can be proved, or if they want to issue an injunction, it can only be through a 5-panel judge, like an appeal court, effectively. But a lone district court judge cannot be allowed to do this. And again, it just undermines the integrity of the legal system in every way imaginable. And that is the real issue here. You've been a Tacitus today, your pushback channel. Thank you for listening.